We'll get started. My name is Renee Reisman, and I'm the Educational Programs Coordinator for California Lawyers for the Arts. We do a number of services for the public. We do these educational workshops, which are online for the time being while we navigate our safer at home orders. And we also have two other services that you might want to know about. We have a lawyer referral information service. So if you're struggling with any legal issues and you need to speak to a lawyer, but you don't really know where to start, go to our website and you can fill out a form with your needs and what you're looking for, and we will try to match you up with an attorney that can help you. It operates on a sliding scale, so if you're worried that you can't afford services, there might still be a chance that this will be within your budget. And our other signature service is our mediation and arbitration services. And that means that if you and another party are having some legal difficulties, we can bring in a licensed mediator that will help you solve the issue before actually going to court. So that's another thing that you can find on our website. So calawyersforthearts.org. But with that said, I now want to introduce Tim Wong. He is our attorney leading this workshop on fighting for freelancers' rights during the age of COVID-19.
My name is Tim Wong. I'm a partner with the law firm of Rosen, Wolfe and Hwang. We're a small practice based out in California. I'm currently in New York to be closer to family, but I typically am out in California. And the topic is fighting for freelancer rights in the COVID era. And so just to give you first a little bit of background about myself, I kind of come to the legal practice in sort of a strange way. I really went to law school in part because I was sort of really interested in kind of attempting to automate lawyers. And so for a period of time, I ran a law firm by the name of Robot and Hwang, and really was sort of interested in kind of what we could do in terms of automating law to make it sort of more accessible to people, right? As I don't need to tell this audience this, legal services are often, prohibitively expensive in ways that prevent people from exercising their legal rights. And I was very interested sort of in the intersection between law and technology. And so the practice that I'm involved in is in some ways similarly kind of offbeat. We represent really kind of odd collection of clients, but we have a really good time doing it. So a lot of them are kind of small scale creative businesses and people who are sort of full-time freelancers. So to give you a little bit of the flavor of the types of people we represent, one of our clients is a guy by the name of Fred Benenson, based out in LA. He's a game designer who did a game called Pitch Deck, which is sort of like Cards Against Humanity, but for dumb tech startups, essentially. And he sort of did a Kickstarter, and we did a lot of kind of IP work with him. Another group that we work with is a small company called Plimpton. They're kind of a digital sort of publishing agency. We work with them on a project called Recovering the Classics, which is kind of working with designers and artists to produce sort of new, nicely designed covers for public domain works. And you can see some of the covers on the slide there. And so the topic of today, not surprisingly, is that a lot of our clients have been hit pretty hard, in many cases, very hard by COVID. Companies are scaling back, they're cutting contractors, and businesses by and large are really kind of limiting their expenses as much as possible. That's really put sort of freelancers and small consultancies in a tough spot, really at the kind of, front lines of the economic wreckage that's being kind of brought about by the outbreak. And we've been watching this pretty carefully because, businesses have been using a variety of tactics, some more legitimate than others, to kind of get out of the obligations that they owe to people, owe to their freelancers. Most frequently and most importantly, sort of the obligation to pay people what they promised. And so what I want to do today is to review some of the scenarios that we see pop up the most frequently in our practice and talk about what some of the best strategies are. So I'm specifically thinking here about strategies for freelancers that really may not have lots of money to begin or bring a lawsuit or spend on lawyers, right? And so the question is, okay, if you're confronted with one of these scenarios, what can you do pretty cheaply to try to assert your legal rights? So just the standard maybe caveat here that you'll hear any lawyer give, this is sort of not legal advice to your specific situation. Instead, it's for informational purposes. Obviously, this is kind of like not designed for specific advisory, but it's instead to give you a little bit of a flavor of kind of what we're seeing and what we think sort of is the best sort of path forwards on some of these situations. So let's just jump into it. There's kind of 4 scenarios that I want to go over, and we'll sort of go from the kind of what I'd think of as the kind of hardest situations for freelancers to situations where there's a little bit more room for negotiation. And so, let's start with the hardest, right? The first tactic used by businesses, not surprisingly, is just to go ahead and terminate the contract, right? So if you're a freelancer, you've signed up to do some contract design work or contract writing or what have you, often there'll be a clause that looks a little bit like this. And if it's well drafted, it'll usually have something along these lines, right? And, just to kind of read it out here. So we have it, right? The engagement of a service provider may be terminated at any time by a company upon notice to the service provider. And hopefully the contract specifies what happens in the event that occurs, right? And so this is a clause from one of our clients, and this one is, I would say, one of the more fair ones that we've seen in our practice. So it says, following termination, the company's only obligation to the service provider will be to pay the service provider the fees accrued for the services. That is to say that you sort of are paid for the work that you've done so far, and outside of that, you're not owed anymore. And I would say that these in some ways present the sort of toughest situation for the freelancer. When the language of the contract is very clear, there's usually not too much room to maneuver. And that goes for how a court would look at this if you ever, wanted to go about bringing a lawsuit on these issues. Courts will basically follow the language of the contract when it isn't ambiguous, right? And so if the contract says if at any time we can terminate the contract, then it's very difficult to argue from a legal standpoint. Moreover, it's worth knowing that, there's two sorts of things that you can sort of threaten to do in a lawsuit. One of them is to kind of go and ask a court for what they call specific performance. And specific performance is where you basically say, hey, you promised me that you were going to do this, and I want to get the court to insist that you do it, right? So this would be following through on the whole contract. So say, you were contracted to write 10 articles, they only got to 3, and then they terminated the contract. You might say, okay, that was a breach, and we want you to do all of it. The other kind is to ask for damages, right? To say, okay, well, I relied on this contract and you broke the contract. I want you to just pay me money, basically. And, I think that the challenge in these kinds of cases when the contract is drafted in a very clear way is that it's very black and white. And even when you were to sort of threaten legal action, courts really don't tend to enjoy giving sort of specific performance as a remedy. So sort of the best you can do is kind of get some money out of it. These situations are a little bit tough, right, when they emerge. I will say, though, that if you're looking at your contract saying, okay, what can we actually do here? We do occasionally find this kind of situation, right? So this is the clause that we saw a little bit earlier, but now actually has the second piece terminated, right? Has the second piece kind of deleted. And this is a genuinely ambiguous situation, right? So basically the way to think about this from a legal standpoint is that the contract says that you can terminate the contract at any time, but it doesn't really say how you divvy up the payments or how the money that was promised under the contract will sort of be dealt with in the event of a termination. And we do sometimes see this kind of situation. A lot of freelancers are either drafting their own contracts or the business that is hiring them is drafting their own contracts. They're not really working with attorneys. And so there's a genuine ambiguity about where the money that is owed to you should go, right? We've actually seen some situations where businesses say, well, the contract doesn't say that we owe you the money for the work that you've done so far, so we're just not going to pay you, right? Which is obviously kind of sticks in my craw as something that I think is kind of a dirty practice. But then there's a situation of, okay, so what do you do from a legal standpoint? And I think there's a little bit more room here. The ambiguity basically creates bargaining room, and the goal here as a freelancer is to basically show that you show that you mean business, right? Because I think there's two ways of looking at this. From a legal standpoint, if these sorts of contracts end up in court, courts basically will try to infer clauses that are sort of reasonable if there's an ambiguity about what's to be done. And they typically won't infer that a freelancer basically chose to sign up saying that if this business cancels on me, that I'm not going to get paid at all. Now, that's one way of looking at it, which is, okay, if we went through the whole rigmarole of bringing a lawsuit, arguing before court, and then having a judge finally decide, that a court might actually go about kind of awarding some real damages here. In the very least, would award you some of the value of the work that you did. Now, that's the kind of law of it, right? I think it's important to think about the practice of this situation, which is that in practice, obviously, most contract disputes will never go to court. But these ambiguities do set up the terms of the negotiation, right? Because obviously the business doesn't want to get dragged into a lawsuit. And you sort of end up in this game of chicken about who's going to be sort of the more aggressive person in sort of pushing for some kind of reasonable resolution here. And so what we usually advise to freelancers is that it's possible to get sort of a formal letter written by an attorney, what's known as a demand letter, drafted up. And that's basically just a quick one-page thing that you can send. And we do think that in these types of cases where there's sort of ambiguity and the businesses are playing in the ambiguity to avoid having to pay, that those demand letters actually do a lot of good, right? Because basically it shows that A, you're willing to hire an attorney, and B, that you're sort of aware of your rights in this matter. And the rights are that there's a genuine ambiguity in the contract and really that the case isn't so clear that they should be able to not pay you. And so I think that there's bargaining room here. And I think in these kinds of cases where you see this sort of ambiguity, there is room to push and to be a little bit more aggressive. I think the law gives you a little bit more traction. So I think that's kind of the first scenario, which is basically businesses are caught in a situation where they don't want to pay their freelancers and they just try to terminate the contract, just try to get rid of it. I think the second type of thing that we see in the space, which is not surprising, is to say, okay, the contract says that we owe you some money. So how about we go and try to renegotiate, right? And we do see this quite a bit as well. So a lot of our clients occasionally hear from people that they work with saying, okay, we owe you the money, but we can't pay it to you right now. And ... would you accept a lesser payment, or would you accept a delayed payment? And this is in some ways kind of fair game, right? To basically say like, hey, the contract says one thing, but we're in a situation where we want to renegotiate. And I think there's kind of two important things to sort of keep in mind here. I think these types of scenarios are ones where they're a little bit outside of the realm of legal. I do think it's sort of a judgment call, a sort of business call rather than a legal call. You may want to preserve the relationship with the business that you're working for, right? On the other hand, you might also feel that they're sort of unjustly trying to pressure you in the situation. And a lot of it will sort of be what you can kind of negotiate out of this sort of specific sort of scenario. But I think that's one consideration, right? Which is that I think like the law is genuinely ambiguous here. Like if the two parties can reach an agreement, then that's the agreement, right? And I think the only important thing here is to make sure you get it in writing and make sure that it is a sort of formal amendment to the contract. Now, I think one tricky nuance that a lot of contractors get stuck by, and I think is worth keeping in mind, is that, from a legal perspective, when a company comes to you and says that they want to renegotiate, they also implicitly acknowledge that they do owe you money. And I think it's super, super, super important to sort of get this in writing if you can. So we, have clients that have gotten themselves into some trouble actually, where a business will come and say, hey, we're really pressed this month or these 2 months. Would you be okay with delaying the payment? And they say, oh yeah, sure, that's okay. And then a few months down the road, that business actually never really comes back to them, right? And you basically want to make sure that, they're sort of on paper kind of acknowledging their duties under the contract, in part because I think it allows you to basically give sort of the legal pressure if you need to basically say, hey, I know we talked about a renegotiation, but first off, like even before we got to that point, you sort of acknowledge that you weren't able to owe up to your side of the bargain, right? So to go back to the freelance writing example, right? Like I produced 2 articles for them. They come to me and say, hey, we want to pay you less or we want to move those payments. It's important to have it in writing to basically say that, hey, you sort of recognize that you owed me, right? And that's kind of the second scenario. And as you'll see, as we kind of go, we kind of go to sort of like situations where I think the freelancer actually has more and more ability to kind of negotiate and where there's more room to kind of push back, right? And not sort of take for granted what is sort of being told you by a business that may be sort of attempting to get out of the obligations of their contract. So the third one is one that we've been bringing up and trying to spread more the word about. I believe, Renee, actually you got in touch because I was tweeting about this particular situation. It's a little bit more technical, but I think it's actually worth keeping in mind because I think there's a legal subtlety here that often gets missed. And I think a lot of contractors, freelancers can get stuck and sort of fall for the trap that's here. So in this kind of third scenario, businesses will often use what's known as a force majeure clause. And I'll show an example of it so you can look for it in your own contracts, after the workshop. Or they'll sometimes argue in very sort of legalese language, like we can't do this under what's known as the doctrine of impossibility. And all of this is these are all legal concepts that basically point to the idea that, look, if something really big and unexpected happens, you can sort of be freed from your obligations under the contract, right? And what we see is that a lot of businesses are arguing this to basically say, hey, no one could have foreseen a massive global pandemic like COVID. And so the contract is now, unenforceable. We a kind of like primary assumption under which we made this contract, didn't turn out to be the case. And so we should be freed. And, believe it or not, this is something that is kind of legally enforceable. And it actually is something that appears in contracts. So to give you a sense of how kind of like intimidating and legally dense the language can be, here's a kind of representative example. It's a little bit painful to parse through, but I'll just read some choice parts about it, right? Choice pieces of the clause. So force majeure, in no event shall the company be responsible or liable for any failure or delay in the performance of its obligations hereunder arising, blah, 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 in situations including without limitation, strikes, work stoppages, accidents, acts of war, terrorism, civil military disturbances, basically this whole laundry list of terrible situations that could occur. And if you're reading it, right, like I feel like I always tell my freelancers that, if the contract is not clearly written, there's no legal necessity often for that to be the case. And so you should always kind of be wary of these types of clauses. And the force majeure one is actually a great example of that, right? So if you do want to kind of squint your eyes and kind of take a look at it, it kind of seems like it might fit the COVID situation, right? So the company won't be responsible for any situations arising out of its control, right? And coronavirus is a situation that arises out of its control. It's not a nuclear or natural catastrophe, but it might be under an act of God, right? All these sorts of things. And, not surprisingly, we're actually finding that not just on the freelancer level, everybody is trying to get out of their contracts right now with force majeure clauses. So here's an article from a publication called Digiday. Basically, there's a lot of ad companies now that are basically saying, hey, I paid for these ads, but I need to get the money back right now because no one really wants to hear me, advertising this product anymore because everybody's worried about a global pandemic, basically. There's some, if you really want to get nerdy about this, there's some really interesting contract disputes happening in the NBA right now because the NBA has a force majeure clause that's built in. And, basically what has happened is that generations of lawyers were trained to just throw this clause in, and no one ever really expected for these clauses to be used. But now suddenly we have a situation that kind of matches it, right? Like this act of God finally occurred. And so it's becoming a big issue with COVID. And so I think there's a couple subtleties to keep in mind here. And I think the kind of big message that I want everybody to take away from this is that if you hear a sort of business that's sort of bringing up a force majeure clause, our advice here is not to be intimidated by the legalese. It's actually a situation where the legal language looks a lot more expansive and a lot more applicable than it actually is in practice. And, the way to think about this is that, not surprisingly, courts are pretty reasonable, right? In some cases, particularly around aspects of contract law. And courts don't want to set up a situation where every time something unexpected happens, people can get out of their contracts. And so it turns out that the legal doctrine around force majeure is actually a very high bar, right? To actually use a force majeure clause, or what's known as this sort of doctrine of impossibility clause, you actually have to meet some very, very high standards. So here's a couple questions I think to keep in mind if you're facing down one of these sort of situations. One of them is actually just whether or not a pandemic is specifically called out in the contract. So a lot of courts in California as well have basically said, look, if you didn't specifically articulate this kind of disaster in your force majeure clause, it just doesn't count, right? Like it has to be something that was specifically contemplated. And a lot of force majeure clauses don't really call out pandemics, right? Like it was funny, the way you can think about this is basically the lawyers tried to come up with every bad situation they could come up with. One of the ones they didn't come up with is a global pandemic, right? And that has actually created a sort of very interesting hole in a lot of these provisions. Just if you're wondering about this weird language, acts of God, capital A, capital G, typically refers to things like natural disasters, right? So what's interesting is it's like storms, hurricanes, those kinds of things are included, but sort of these biological things are not. And if you really want to get nerdy about this, there's a whole world of kind of legal technicality to get into. But I think the first thing to keep in mind is just, is the pandemic something that's specifically called out, right? And the legal doctrine and the law will tend to support you if a pandemic is not specifically called out. And indeed, actually, if you do a little bit of research, you'll find that a lot of law firms now are advising their clients just like shove this language in now. Second one is that the force majeure clause, here's an interesting subtlety, is actually only enforceable if the performance is actually impossible, right? So the way to think about this is that there's a lot of cases with force majeure where you say, okay, I'm a theatrical performer that's about to do a show in your theater, and you've booked me in this theater. And now the theater has burnt down like a week or a few days before the performance, like totally destroyed. There's nothing to do, right? The argument there is that the performance is actually sort of impossible. Like the theater company, or the company that owns the theater rather, can't provide you the venue because it just doesn't exist anymore. And this is actually really important in the specific situations that we're seeing around COVID, right? Because in COVID, what's happening is that basically businesses are saying, look, we can't pay you, right? And that's why because of the pandemic, we can't actually issue the check that we promised. I think the counter here, especially in the context of force majeure, is to say, well, is performance actually impossible? Like, is it actually impossible for you to pay me because of this pandemic? And the answer is by and large, no, right? Like the banks are still running. And there's the sort of legal doctrine is basically that like, just because something's sort of like difficult or more inconvenient to do, it isn't impossible. And so like impossibility is really the standard here. And so, these clauses really aren't applicable in the way they might initially look, because often what you're trying to ask someone to do is just like, hey, put a direct deposit into my account, or just like send me something on PayPal. And like those systems are all still working. And it's important to keep in mind. And I think that's an important way to push back. Finally, I think it's worth keeping in mind that these force majeure clauses also rely on the question of like whether or not there were any reasonable steps that could have been taken to mitigate the situation, right? So occasionally we'll hear from freelancers that say, hey, a company hired me and they knew about this pandemic for months and months and months and months, right? And they knew that events were canceling all the time, right? We heard from someone, for example, who was doing an event that was supposed to be in April or something like that. And the fact of the matter is if you knew basically that this pandemic was happening and that lots and lots of people were canceling their events, you could have also done things to kind of mitigate this. You could have, delayed the event or rescheduled the event or figured out how to do the event digitally, those types of things. And I think if there's sort of reasonable steps that could have been taken to mitigate, the force majeure clause also doesn't apply, right? So as you can see, the bar is just set at a very high level. It really has to be something that's very unexpected, that makes it entirely impossible. So I think this is actually a case where I think it's worth it not being sucked into the trap. And if you do see these clauses being used to kind of know these facts and be willing to sort of push against them, because I think the situation is actually a lot better for freelancers than it might otherwise look. Okay, so that's scenario number 3. Scenario number 4 is maybe extra legal, if you will. So these are situations in which the client just ghosts, right? The business just like walks away. And this is unfortunately more frequent than not, right? Basically businesses are like, well, we know the law is against us. The contract is very clear about what we have to do. We don't want any legal trouble. So maybe if we just don't talk to the freelancer, the problem will just go away. And this is a situation where the law is against the business and they really are trying to wear you down. I think it's kind of a war of attrition in some ways. And what we tell people here is that there's sort of a couple things to make sure that you do. The first one is to send a formal demand letter, but also make sure that that delivery is something that is tracked in some way. So the kind of most old school way of doing this is to send a certified letter or like a tracked letter, right? Where you can know that someone signed off and like actually received the thing that you sent them. Other people have been trying out different ways of doing this. Believe it or not, like a lot of people are using read receipts where they like send something over like Facebook message. And when someone checks it, they're like, oh, okay, now we have actually evidence that you saw this demand. And what you're trying to do here basically is to create a paper trail. You want it to basically be documented that you didn't sort of accept the fact that they weren't going to pay you. And that in fact, like you sort of exercise your rights. And the important reason for doing this is that you want to avoid the argument later that some businesses will bring, basically saying, well, we never heard from you. And because we never heard from you, we assume that you sort of deferred the payment on this. You were just willing to give it up, basically. So I think, again, I think there's, even if you draft this demand letter on your own, which you can do, again, I think there's nothing magical about having a lawyer do it. I think the important thing is to make sure that it's sort of tracked in some way. So you really have like a date where you know this was sort of received by the person. I think the demand letter is useful, but again, I think the problem with ghosting is that when they're ghosting you, even if they send the letter, they might not get back, right? And the game here is then how do you play the game of sort of escalation? And I think there's a couple of strategies here, right? I think the first one, which is kind of low cost, but is actually very useful here, is outside of hiring an attorney. I do think actually the press can be your friend in a really big way. And I think social media can really be your friend in a big way. I think there's a lot of journalists that we're finding that are really kind of on high alert for these kinds of stories. I think in part because I think it's becoming obvious about how kind of uneven the impact of COVID will be on various businesses and individuals. And so I think you shouldn't be afraid to kind of spread the word about your problem. And in some cases, outside of any legal work that we do at Rosen, Wolfe and Hwang, we do find that sometimes just like working with the press to spread a story, basically saying, hey, this employer that clearly may have just gotten a huge amount of money from the payment protection program or the other federal programs, that kind of pressure is actually very helpful at making sure that they say, okay, well, we tried to ghost this person, but now the kind of PR hit we're taking is so big that we actually want to come back to the table. And so I think that's worth keeping in mind. And I think that is kind of a way of playing the legal game that doesn't rely on any lawyers at all and is low cost. I think the second one to bring to your attention too is that you should consider doing small claims court as well. Because I think the fact of the matter, right, is that most freelancers don't have the resources to bring a formal lawsuit. And there are still a few options you can pursue. So in California, small claims court is pretty easy to navigate, even if you don't have any legal experience. I think California is actually relatively good in terms of providing kind of documentation to make it as self-serve as possible. And you can sue for anything up to $10,000, right? And so this actually covers a relatively large number of cases where you might not want to hire an attorney, they're continuing to ghost you, and a kind of substantial amount of money is on the table, right? It's something that you might really want to get from them. And we've had a few clients have some successes in going down this route, and I think it's worth considering. I think the other option, I didn't actually know, Renee, that CLA offered the kind of mediation services, but I think I'd actually put in a plug for that as well, right? I think sometimes what happens with the ghosting is malice, right? That the business is actually like, no, screw these people, we're actually just not going to pay them. But actually sometimes I think like the ghosting occurs just because like the person is legitimately kind of like scared of the implications of the situation. And I think mediation is kind of helpful in that it creates kind of a third party, a formal process by which people can go through and reach some kind of resolution in the dispute. And so if you don't want to necessarily bring the hammer down and do a small claims court, I do think mediation is really a good way of kind of approaching some of these types of problems. I think the most interesting part of these conversations tend to be sort of questions that people have.
What are some ways a freelancer can negotiate for a safer working environment, considering the current health concerns?
Particularly if you're in the situation now where you're sort of like you're negotiating a contract. There's sort of the law of all this, and then I think that there is the sort of PR of all this, right? And both I think are important sort of considerations to keep in mind. I think the law is right now, unfortunately, not very friendly to freelancers on basically saying like you have to offer these types of protections, right? Particularly when it goes to a situation like PPE. And so in my knowledge, like you don't have too many legal levers to push on to basically say, hey, unless there's been a local ordinance or something passed, right? Again, so much of this has happened so quickly that I think, unfortunately, we're living in a world where the law is still like slow to catch up. And so part of the problem here is that there's not much you can directly lean on in many cases, right? Unless you happen to live in a jurisdiction that has taken some aggressive action on it. And so I think part of it is arguing just from sort of like workplace safety. But I think the other thing about it is I think that like businesses are genuinely concerned about, making sure that they look like they're being safe around these sorts of things. And so I do think that this is kind of like the PR dimension of it that I mentioned, that I think it is worth sort of pointing out to the employer, like, hey, in addition to worker safety, which you should be concerned about, it's also worth thinking about like the fact that like this sort of does not look good in a broader way for the business. And I think that is worth kind of calling to their attention, because I think, unfortunately, we do live in a world sometimes where the businesses are more concerned about their image than they are about the freelancers. And I think that is something that's worth emphasizing with them.
Do you know of any resources for people who are just starting to do freelance work?
Yeah, so there's a group that I really like from a few years back, and I think they were very active in New York. And I don't actually, it's worth taking a look. But this sort of the Freelancers Union, I think, is a really interesting organization. I think they're doing a lot of interesting work on kind of like getting you sort of familiar with sort of the world of freelance. And so I think that would be the major source that I would take a look at.
Does it make sense for a freelance worker to incorporate themselves into an LLC, or is just being a sole proprietor fine?
The way to think about sole proprietor versus LLC is really how much money you think you'll be making from your freelance work. So sole proprietor, you actually don't need to do anything to get one. You don't have to file anything with California. All you really need is a tax ID number, an EIN, right? Which you can actually just get through the IRS website. And then what you do is on your tax filings every year, you prepare what's known as a Schedule C, and you kind of just report your income through freelance under that tax ID. And so sole proprietor is like very easy to set up. The main problem with it is twofold. One of them is liability, right? So the nice thing about the LLC is that if you ever end up in a legal dispute, the nice thing about the LLC is that only the assets of the LLC are at risk, right? Versus the sole proprietor, where if you're in a dispute, legally, all your assets, all your personal assets are subject to damages or anything else that you might run into. So it's really kind of this risk reward calculation that you need to make. The other main reason to get an LLC outside of insulating your personal assets is that you can get a bank account really easily under the business name. And some people like that basically, because rather than being like, just write me a personal check to Tim Wong, you can be, write a check to Robot and Hwang LLC. And some people like the formality of that. It shows some seriousness in a way that people like. I think the main downside is that as a California freelancer, you have to incorporate your LLC in California if you're doing business there. And the filing fees can be pretty, depending on how much money you're making, can be pretty hefty, right? So annually you owe about $800, and there's kind of some regular sort of filings you need to do with the state of California. And so, it is money for sure. And so, it depends really on kind of like, what you think sort of the annual sort of take from your freelance work will be. Generally, I think it's a good idea just because one never knows when they're going to end up in a legal dispute. And I think it is beneficial to have it kind of separated as its own legal entity, but it's not necessary for the perspective of like starting to freelance on your own.
If you are an employer, what are the things you should consider to best protect yourself and your workers?
Ultimately, the way to think about contracts is that it's just a way for people to formalize their relationship, right? And so rule number one has to be just like making sure that the expectations are clear on both sides, that both of you have kind of thought through what happens if like things turn sour, right? And that's really all the contract is. And I think that like 80%, 90% of legal problems just come from the fact that they didn't want to have that, like two parties didn't want to have a painful conversation up front. And now they've ended up in this ambiguous situation. And so I think the big thing is to be clear and honest about like financially where you are and what your plan is, right? If something doesn't go right. So I think that's the first one. Second thing that I think is important is to hold insurance if you're employing people, right? Because I think some of the problems here come from businesses basically saying, well, we have a dwindling bank account. We got to look after ourselves now rather than look after the freelancers. And in some cases, it's because that they didn't actually take out adequate business insurance to deal with some of the problems that they're dealing with. And so I think that second piece is actually really important as well. I think a third one that is also really important is to make sure that the sort of payment structure is really clear. As I mentioned, right, like in the scenario number one that I mentioned, where, they just try to terminate the contract. That kind of isn't so bad if both sides sort of know what's coming. And it isn't so bad if the contract actually says like, here's how the money will be distributed if it terminates at this point or that point, right? And this is something that you don't, again, really need an attorney for. I think it's important just like to be able to say like, hey, we had that conversation and now it's written down here in the contract. And so I think it's worth, clarifying, what happens to the money if the project needs to end early. And I think that's another key thing to do for sure.